Hi everyone. Today we would be doing the analysis of your Mock 1 legal aptitude portion. As you all know, the legal portion comprised of 35 questions on that were based on legal reasoning, and there were 15 questions, that is from 186 to 200, that were legal knowledge questions. So today we will be doing a brief analysis of the entire legal portion. Moving on to the first question, that is question number 151. It dealt with the concept of Article 21 of the Constitution, and the facts were such that Baba Vasudev, he held a camp in Pragati Maidan with the motto "Remove Corruption." He was granted the permission to hold the satyagrah, which had more than 50,000 men and women. Then there were some negotiations between Baba Vasudev and some government authorities, but Baba Vasudev was stern about his demands, and later at about 11:15 p.m. the central government representatives reached Pragati Maidan with a letter assuring a law to declare black money hoarded abroad as a national asset. However, Baba Vasudev requested a public announcement by the government the next day. Convinced that Baba Vasudev would not finish the protest at 11:30 p.m., a team of police informed Baba Vasudev that the permission to hold the camp had been withdrawn. So you can see that at 11:30 p.m., Baba Vasudev was informed that the permission was withdrawn, but at 12:30 a.m., a large number of police personnel, around 3,000 men, they reached the Pragati Maidan, and that time the protesters were sleeping peacefully. So a scuffle took place between the security forces and the supporters of Baba Vasudev, and 8 rounds of tear gas shells were fired. By 2:10, almost all supporters have been driven out of Pragati Maidan. So these were the facts. Now question 151 said, Baba Vasudev filed a writ against the brutality of police action towards his followers who were sleeping, since sleeping is a part of the fundamental right to privacy. Now, it is important to look into this question that although Baba Vasudev was informed at 11:30 p.m. that the permission to hold the camp had been withdrawn, but it is not a sound action on the part of police to come and attack the people who are sleeping there peacefully with tear gas shells, and that too at 11:30 at night. That is not a reasonable time at all. So we can definitely see that there was brutality of police action. So therefore, among the options that are given there, option C says the action of police was not justified as the followers had a right to privacy, which included right to sleep peacefully at night, which is guaranteed by Article 21 of the Constitution. And the matter could have been taken up next morning rather than at 12:30 a.m. at midnight. So we can see out of all the options, this option fits in the best for the question that is to be decided. Option A says that the demands of Baba Vasudev had been fulfilled, and thus the action of the police was justified. So we can see clearly that although his whatever demands were there, they were justified, but he asked for a public announcement, and such an action taken by the police at 12:30 at night, that too when people are sleeping, cannot be said justified in any way. That is why answer C is the correct option. Now question number 152. What does it say? Would your answer change if the police had visited Baba Vasudev while he was sleeping at 11:30 p.m. and asked him to vacate Pragati Maidan the next day early morning by 9 a.m. as the permission to hold the camp had been withdrawn? So if the police would have taken such an action, that would have been very reasonable, and of course something like this, if would have done, then the answer would definitely be a yes. Okay. Fine. Now moving on to the next question, that is question number 153. It deals with the concept of damnum sine injuria and injuria sine damnum. Damnum sine injuria means damage without any legal injury, and injuria sine damnum means there is legal injury but there has been no damage. So, if we look into the facts of this case, we see that one person has has dug a pit and had been pumping out water to keep his pit dry, and this pumping out of the water has led to the drying up of the well of a person who owns the adjoining land. So the person who was digging his pit and pumping out water had although caused damage to the other party, but no legal infringement of right had been there. As we have seen that most of the students have marked B as the option, that is Ritik is liable even as though he was exercising his legal right of getting water into his land. He infringed upon the right of Asif to get water in his well. He did not infringe upon the right of Asif. He was merely exercising his own legal right. So this is a perfect case when there has been a damage but there has been no legal injury. Okay. So therefore the correct answer to this question is A. That Ritik is not liable as he was exercising his legal right of getting water into his land. Option B is saying that he was exercising his legal right but at the same time he infringed upon the right. But Ritik did not do anything on Asif's land. He did not infringe upon any right of Asif. He was merely doing anything that was possible to keep his own land dry. So therefore, he had although caused damage but no legal infringement has been done. Therefore, A is the correct answer. Coming down to question number 154. This is also a question where there has been a slight doubt. Now in this question, principle 1 says when two or more persons make a joint promise. Okay, when two or more persons make a joint promise, the promisee may, in the absence of a contract to the contrary. This is the most important part of the principle. In the absence of a contract to the contrary, compel any of such joint promises to perform the whole of the promise. So over here, when you look at the facts, there are two brothers who are renovating their ancestral home and they enter into a contract with Z. But when you see the facts, the sign says the claims under the contract were to be raised against both the brothers. So this contract had this particular condition that the claim of the contract were to be raised against both the brothers. And the principle says when two or more persons make a joint promise, the promisee may, in the absence of a contract to the contrary, compel any of such joint promises to perform the whole of the promise. But here a contract was already made where such a condition was laid down that the claims would be raised against both the brothers. Therefore, when Z has claimed the payment only from X, that particular claim cannot be upheld. That is why option C, that no, as Y has not been made a party to the claim. This is the correct answer. Okay. Moving on to the next question, question 155. Now, again, this is one question where a lot of students have marked B as the correct answer. The principal says a contract with a minor, that is a person who is below the age of 18 years, is void ab initio. That is, the contract does not exist at all. The contract is void from the very beginning. Ratification relates back to the date of making the contract. Ratification means agreeing to bring into the effect or continuing the contract, the agreement. That is your ratification. Agreeing to something, basically. So, in this particular case, although when the contract was made, when the two parties A and B, they entered into a contract, at that time the party was minor. That you can read in the facts. A purchased a gold chain from B. At that time he was a month shy from turning 18. Okay, that means he was 1 month away from turning a major. After 2 months of the purchase, he executed an agreement with B in which he acknowledged his debt and promised to pay back the amount due for the chain. So, when this principle says a contract with a minor is void ab initio, that means from the very beginning, the contract is considered to be null and void. So, how can you ratify a contract which is not existing at all? So, option B says yes, as A acknowledged his debt after attaining the age of majority, thereby ratifying the earlier contract. So, how can you ratify a contract? How can you agree to a contract which doesn't exist at all, which is void ab initio? So, that is the catch in this particular question. So, the correct answer for this particular question is A, that is no, as the contract was made when A was a minor. No valid contract has been made, hence he cannot be made liable under the contract. Okay, that is the reason why B cannot be the answer, because you cannot ratify or you cannot bring into effect any contract which is void ab initio. If it is not a contract at all, how can you agree on it later, or how can you acknowledge it? From the very beginning, that particular contract did not exist at all. That is why A is the correct answer. Moving on to question number 156. It was a very easy question. The principle dealt with the word injury denotes any harm whatever illegally caused to any person in body, mind, reputation or property. So, as per the facts, we can easily concur that B is the correct answer option. The income tax officials are not guilty of causing injury to A, as they were acting in accordance with the law. Moving on to question number 157. Again, this question was a very simple question. Most of the students have got it correct. The principle dealt with the concept of cheating, and as per the facts, we can easily come down to option A as the correct answer, that Manohar had fraudulently induced Sudhanshu to pay 50,000 rupees. Next, moving on to question number 158. Now, question 158 deals with the concept of extortion. And the fact says that A threatens to send goons to blow up Z's field unless Z signs and delivers to B a bond binding Z under a penalty to deliver certain produce to B, and thereby induces Z to sign and deliver the bond. So we can clearly say that yes, he has committed extortion. Why? Because he has put Z in fear to coerce him to sign the bond in favor of B. Therefore, A is the correct answer. Next question was question number 159 and 160. Both of them have this common set of principles and facts. Now, question number 159 says, Okay, both these questions, the principle was nothing is an offense which is done by an accident or misfortune and without any criminal intention or knowledge. Without any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means with proper care and caution. Okay. Now, question number 159. X was digging earth with a spade. The top part of the spade got disjointed and hit Y, who was collecting the mud nearby. On inspection, what was found? That the spade was rusted, which resulted in the entire accident. Now, X pleaded the defense of accident. As from the facts, we can see that the spade was rusted and he had the knowledge. X had the knowledge that the spade was rusted. Therefore, we can clearly say that he had not taken proper care and caution, as it is given in the principle that nothing is an offense which is done with proper care and caution. But in this case, we can see that proper care and caution was not taken in spite of knowing that the spade was rusted. Most of the students have marked answer C, that is X pleas will be upheld as the unfortunate event happened without any criminal intention while doing a lawful act in a lawful manner. We agree that X was doing a lawful act in a lawful manner and it was an unfortunate event which had happened, but we can also see that proper care and caution on part of X had not taken place. He was not careful in spite of having the knowledge that his spade was rusted. As we can see that all the three options are saying that the plea will be upheld, but because there was no care and caution, this plea cannot be taken. The plea of accident cannot be taken. That is why D, none of the above is the correct answer. Coming down to question 160. This was comparatively easy as compared to the last one. In this, X was carrying on the business of production of narcotic and psychotropic substances for which one needed to obtain a permit license from Central Bureau of Narcotics. Now, X had applied for the license to run such a business, which was abated. The process involved use of large boilers to heat water. The boilers were imported from abroad and were best available anywhere in the world. X ensured that the boilers were used according to the instructions of the manufacturers. Due to some latent fault in manufacturing, one of the boilers burst, causing injuries to several workers. On being charged, X pleaded the defense of accident. Now, we know that a permit license from Central Bureau of Narcotics was required to carry on the production or manufacture of such substance. X had applied for the same but had not been granted the license yet. So therefore, as we know that he has not yet got the license, such an act would be considered an unlawful act. It would not be lawful. Although he had applied for it, but he has still not received it. Moreover, that is the reason that he cannot plead the defense of accident. Therefore, answer is option 2, that is option B. That X cannot plead the defense of accident as he was involved in an unlawful act. Most of the students have marked this only as the correct answer. So, we see option B is the best option. Now, moving down to question number 161. Now, this question again has been a little debatable question because most of the students have marked A as the correct answer. It is, see, when we read the principle, it is important to read the second line, that is, by the person to be charged with to pay wholly a debt. So in this, the debt that has to be paid wholly, which the creditor might have enforced payment but for the law of limitation of suits. So whatever debt has to be paid off has to be paid wholly. Now in the facts we can see that A gave an oral promise to B to pay half the amount he owed to B. So we saw that in the principle it says that you have to pay a debt wholly, but in the facts we can say that A promised to pay B but he promised only to pay half the amount. That is the reason it cannot be enforced as a promise. Therefore the correct answer option is D, that no, as A merely promised to return half the amount he owed to B. Whereas most of the students have marked answer A, that is, as the promise was not written and signed, he cannot enforce the promise against A. So this is not the correct answer. Although answer A also is saying that the promise cannot be enforced, but the reasoning given by option A is not correct. The correct answer for this question is option number 4, that is option D. Now coming down to question number 162. Now this question deals with, the principle deals with the article 19(1)(g) of the Constitution, that is the right to practice any profession or to carry on any occupation, trade or business. Then the second principle is the state would not discriminate against any citizen on ground of religion and the freedom to exercise any religion. And principle 3 says the fundamental rights are applicable only to laws made by or administrative actions of the state and would not be applicable to actions of private persons. Now, as for the facts, we can say that the Jesus Theatre was a private institution and it is not a state body. So therefore, option number D is the correct answer. Most of the students have marked D as the correct answer. Therefore, it seems that it was not a very difficult question. Okay, now coming down to question number 163 and 164. Now both these questions have the same principle and facts. The principle is that of an inevitable accident, and the fact says that the person was cleaning a gun and he kept it on the table. His servant came and took the gun for shooting and came back and placed the gun at the same place but placed it fully loaded. So when the master came back again, he started cleaning it up again but accidentally killed his daughter who was playing in the room. So will there be inevitable accident or not? So question number 163, it asks that whether Raju will be liable. So most of the students have marked B as the option, that is Raju will be liable, as he should have checked the gun before firing. Now he knows that he was cleaning a gun and he had kept it on the table and the gun was empty while he was cleaning. Now for him to foresee that during the time he was not there, during the time he had gone to attend the urgent matter, his servant had taken the gun, loaded the gun, taken it out for shooting and then came back and had kept it on the table. To foresee something like this is not possible. He knew that fine, he had he was cleaning the gun and he had kept it on the table. So for him, when he came back and he saw that the gun is placed at the same place where he has left it, he obviously thought that nothing has been done with it, it has not been tampered with at all. Therefore, option number A, that is option first A, that is Raju will not be liable as it was merely an accident, that is the correct answer. Option B says he should have checked the gun, but that is more of an ideal answer, that what he should have done. The principle says inevitable accident is that which could not possibly be prevented by the exercise of ordinary care, caution and skill. So as your principle says could not be possibly prevented by exercise of ordinary care, caution and skill. So for him, when he left the gun at the time he was leaving, he exercised ordinary care and caution. So when he came back and he sees that the gun is lying at the same place, it is a very far-fetched thinking that the gun will get loaded and it would have been used. So that is why for this particular question, option A is the correct answer. Coming down to question 164. What if Bhola, while unloading the gun in a hurry, shot Madhurika by mistake? Would he be liable? Yes, for this case, he would be liable. So option A would be the correct answer. And why he would be liable? Because in such a case, as he did not exercise due care and caution while unloading the gun, that is, he was doing it in a hurry, which led to the death of the girl Madhurika. That is why if you're doing something like this in a hurry, that would be termed as not exercising ordinary care and caution. Therefore, for 164, the correct answer would be option A. Coming down to question number 165. Most of the students in this question have marked option B as the correct answer. That is, Y had the right to rescind the contract as X disabled himself from performing the contract, therefore did not perform the contract in its entirety. Now in this particular question, the principal said, when a party to a contract has refused to perform or has disabled himself from the performance of his promise in its entirety, the other party may put an end to the contract unless the other party has signified by his words or conduct his acquiescence in its continuance. So, you have to read the first line of the principle together. That when a party to a contract has refused to perform or has disabled himself from performance of his promise in its entirety, that the person who is refusing should refuse to perform the entire promise, the entire part of the promise. But in this case, X, who was engaged to play violin, he presented himself on the first day. Therefore, he did not refuse to perform his promise in the incomplete scenario. He came for one day. But your principle says that the refusal of the promise should be in the entirety. That is why Y do not has the right to rescind the contract. And the correct answer for this question would be option D, that is none of the above. Now coming down to question number 166. The question seems to be an easy one because most of these kids have marked D as the correct answer option. The principle given is that of theft, and the correct answer as per the facts and principle is option number 4, that is option D. Ravi is guilty because he had taken the watch out of the possession of Shyam without his consent. That is why he has committed theft. Now, moving down to the next question. Question 167. Again, a pretty decent, simple question which most of the students have attempted correct. It's a question of bigamy. The principle talks of bigamy, and as per the facts given, option B is the correct answer. That is, Mayank is guilty of bigamy. Moving down to question number 168. That is dealing with whoever carries on a dangerous activity shall be held responsible for any harm that may flow from the activity. So we can see the principle is talking about a dangerous activity. And in the facts, the person who has been sued is a person who is having a Ayurvedic medicine farm. So as you know, Ayurvedic medicine is such sort of a medicine which does not have any side effects also. So it's one of the most herbal and the good for health medicine. having such a farm cannot be termed as a dangerous activity at all. Most of the students have attempted this question incorrectly. Most of the students have marked A as the answer, that Ramlal is liable as it was his responsibility. But the correct option for this question is option B, that Ramlal is not liable because he was not carrying out a dangerous activity. That is why option B is the correct option.